Thank you so much for joining us. I suppose before I thank you all, I should thank Arun and ORF and all of the amazing work that was put into putting this event together. I'm excited to see so many people in the room to talk about MLAT reform, although that excitement is tempered a little bit by the fact that you all have chosen to be here when there's an event on the future of entertainment going on right next door. So I question your judgment. But what I thought I would do, given the limited amount of time and the rich expertise on this panel, is just briefly, so that we're all on the same page, give an overview of what I think of as the MLAT problem, the cross-border data request problem, and then pose a few questions to our panel. So why are we talking about MLATs? Why do MLATs matter? Why in an internet and jurisdiction conference are we talking about law enforcement's ability to cross borders? And the answer is that we used to live in a world where law enforcement agents, let's say in India, could pursue the vast majority of the evidence connected to the vast majority of crimes that occur here solely within their territory. The evidence of a crime that occurred in India was most often, vast majority of the time, here in India. And that's not true today anymore. Today, Indian government, Indian law enforcement is seeking evidence connected to a crime, and very often that evidence will be digital, and very often the digital evidence will be stored or controlled by an American company, a foreign company, which 9 times out of 10 is an American company. And American law makes it very difficult for that company to comply with the Indian law enforcement request for that data. Essentially, the American company, when the Indian police come and ask for evidence connected to a crime that occurs here in India, the American company says, please go through the MLAT process. That is to say, make a request using the Mutual Legal Assistance Treaty process between the Indian government and the American government. And this happens all around the world, as long as there's an MLAT in place. And that process is incredibly slow. The average response time has been estimated at 10 months. And there are things we can do to speed it up, but there are also some things we could do to essentially work around the problem entirely. And so that's what we're here to talk about today. And so I thought I would start, maybe I'll start down here with Samir, and just kick it off to the panel. I'd like to hear from each of you, given the range of reform options available to us. Let's say there are at least 3 reform options. The first is speed up the existing MLAT process, bring more people into the MLAT fold, more countries where there isn't an MLAT, a bilateral MLAT or a multilateral MLAT agreement, bring more countries in. That's option number 1, right? Fix the current system. Option number 2 is develop an alternate, better, faster, more direct system, something akin to the US-UK proposed agreement. So you will hear, if you don't know about it already, about the proposal that the United States government and the British government have been working towards to essentially work around the MLAT process with regards to digital evidence. So that's option number 2. Option number 1 is fix MLAT. Option number 2 is work around MLAT. And option number 3 is something even more ambitious, like a global treaty or amending the Budapest Convention so that the Budapest Convention directly addresses this particular problem. So I'll start with Samir, and we'll move down the line, and I'd like to hear your thoughts on reform options.
Great, thank you. Is this working? Okay, thanks. So just to get to the bottom line first, I would say a combination of A and B at least. I think, the United States, we're committed to both of those steps. On the MLAT reform side, I think we all recognize that, for the reasons Andrew laid out, that the current MLAT process isn't going to scale to deal with the volume of cross-border requests that are just going to inevitably arise given the increased amount of data that's stored overseas and the like. So the current system isn't working. So I think one piece of it really is MLAT reform. And I think it's MLAT reform on both the receiver side and the sender side. So on the receiver side, for example, in the United States, we have committed substantial resources that the Congress has given to expand our resources in our Office of International Affairs to process MLAT requests. I think over time we can make some aspects of it at least electronic so that it can be more efficient in that way. Conversely, I think one of the inefficiencies in the MLAT request is that so often the MLAT requests that come in don't contain the information that is needed to actually take it to a U.S. court and obtain the information that's being requested. And so I think capacity building on the side of those who are sending MLAT requests, working with them to make sure that they understand the information that we need, that's an important piece of it. Centralizing the request process so that it's not hundreds of different police stations in a country, for example, sending MLAT requests, because there's no reason they're all going to understand what it is that the United States needs to meet a probable cause standard. And so having some kind of centralized authority in countries to send MLAT requests, I think also is going to be helpful. So part of this, I think, is reform of the traditional MLAT process. But then another piece, and Andrew alluded to this, is what is some legislation that we have introduced in our Congress that would create sort of an alternative mechanism for at least a subset of the problem. And it deals specifically with situations in which a foreign government is seeking information about a non-US person with respect to a crime that's committed in their jurisdiction. And in that context, I think we recognize that for various reasons, the MLAT process isn't going to scale to that. As Andrew mentioned, our service providers in the United States are faced with sort of a legal conflict, because on the one hand, in the United States, our Electronic Communications Privacy Act essentially says that as to content and emails, they cannot provide it to anyone other than the US government with appropriate legal process. On the other hand, they may be the subject of a legal obligation in the UK or India to provide that, and they're faced with this irreconcilable conflict. And we also recognize, I think, that absent solving this problem, we're going to create major incentives for data localization, which I think from our perspective is a bad thing. It's a bad thing both for the economics of the internet, it's a bad thing for privacy, and so we don't want that to happen either. And so what we have proposed is a framework under which we would reach bilateral agreements with various countries, and we've started with the UK for various reasons, among them that their legal system is most similar to ours. But essentially what it says is that if a country has, at a general level, sufficient privacy and procedural protections, and the request is made subject to various criteria, such as oversight by a judge and other criteria, that kind of a request with respect to a country with which we've reached this agreement can be served directly on our provider, and the provider can, although they're not obligated to under US law, then provide the information in response. And the notion is that for those, and again, this is restricted to requests that don't relate to US citizens or US persons. And so for that subset of requests, ones in which the country that's making the request has a really strong interest, and where we've reached this agreement and these various criteria that are laid out in the legislation are satisfied, then they can go straight to the provider, and you don't have to go through the MLAT process. And so it's meant as a mechanism, as an alternative mechanism to deal at least with some requests. And it's a bit of an experiment. Congress still hasn't passed this legislation, and that's going to probably slip into at least next year after the elections. And then once that legislation passes, we'll have to reach the agreement with, for example, the UK, which is where we're starting. And over time, our hope is that the framework will be flexible enough so that it can be extended to other countries as well. So let me stop there.
Great. Anna?
Thank you, Andrew. It's very true, as you say, that we often hit upon a number of problems of different kinds in the MLAT process. We see a lot of procedural delays. Getting answers from some countries can take up to 12, 18 months. And time is always an important factor in criminal investigations, especially when it comes to e-evidence, as information is often available only for a short period of time. And we also see different countries, they lack rules, legislations on data storage or access to subscriber data altogether. But I don't think that's a reason to give up on the MLA process. I think we should work mainly with reform from inside, as in all legal cooperation, it's important to accept and see beyond differences in each other's states' legal systems. If we get stuck in too narrow interpretations of terminology or too narrow definitions of dual criminality, for instance, well, yes, then we get stuck. But there are ways around that, and that is mainly communication, I would say. Get the different services of different states talking to each other, giving the issuing authority a chance to explain the requirements and the problems and the uncertainties that you find in the request, instead of just putting it aside and dealing with something else. So I think we have to try to build trust between the legal practitioners in our different judicial systems. So what I'm saying is, don't give up on the old systems, but still you have to also work with new ways of stepping up cooperation. And one way of taking these kind of investigations forward is to enhance cooperation with private actors, and that is something we have done in Sweden and have great experience with. I think cooperation in particular with US and US-based corporations has been a key for fighting cybercrime in Sweden. The Swedish police have established agreed ways and procedures for requesting and accessing information from a number of US-based corporations such as Facebook, Google, Ask, Apple, and we're trying to get agreements also with other corporations. And in practice, this means that Swedish police can get access to a number of different contact or non-content data in less than 14 days. That's a whole lot of difference to 1 year. So this works very well. And these agreements have been made possible because of the possibility and the legal, it's within the legal powers of the US corporation to voluntarily disclose non-content data. And we're very thankful and happy that that is possible within the US legislation. And I think it's safe to say that Sweden's been a forerunner in this sort of work, and we would very much like to spread the word. For us, this has worked especially well because we have had appointed single points of contacts within the police. So they are the contact points to the corporations. So it's not anyone within the police that could call the corporations and ask for request, but they have specific contact points, so they know each other, they trust each other, and they know what kind of processes they should be following and what kind of information they are likely to get in a voluntary disclosure. So I think that is a very good way of speeding up the process for more simple kind of request. But we couldn't do without the MLA process, of course, because that's very important to adhere to fundamental principles and legal principles.
Right. Great. Thank you. And Dr. Rai, before I turn the mic over to you, I will just like to preface this by saying that over the last day and a half, I've asked a number of Indian government officials about MLAT reform, and every single one of them has either mentioned the US-UK deal or the Budapest Convention. So I'd be curious to hear your thoughts on both of those as well.
When you started this thing, you gave 3 options. And I just take up, first of all, I must clarify that what I'm going to say now, I'm saying from my experience and individual capacity. I'm not speaking for the government. Those comments can be modulated depending upon many other things there. So that caveat I'm putting it. See what, if you look at the MLAT process, and I have seen it for a number of years, and to some extent I raised the basic issues there. MLAT process, to the best of the capability, it takes more or less 8 to 10 months if everything goes all right. The two caveats are there, and I request Samir and my American friends to bear with me out what I am going to say. One is that when the request is made by a country A to US government, it is evaluated, the time period for evaluation, there is no any hard and fast rule, it has to be done in so and so time. So it depends upon my priority. Even if you relax the MLAT process, what Samir said, how do you address this part on a part of a government, any government there, that this has to be done in a more transparent and objective manner? That part, one part is there. The second part is there, you decide that I will handle the case, let us say in 1 week's time. Then the case has to be presented to the federal court as per the laws of US or laws of that country. That's the normal. How do you present the case to your respective court? That's another angle which comes in this process there. Now when you look at the second factor, a crime happen in India, if you see the crime happen in India with respect to the lens in some other country, is that fair? The laws may or may not be same, or the perspective, the cultural aspect of one country A and country B may not be same. How do you address this issue? You relax the MLAT, but these are general problems there. Now, as I said, the MLAT cases take minimum 8 to 10 months in a most experienced case, but time lot. Can we wait even the most best cases 8 to 10 months in case of cyber? And many of the cases may not be crime related cases there. Maybe you will just get data for the intelligence purposes there. The other aspect, Arun told me you have 10 minutes, so I didn't cover. The issue that we are talking about a free flow of information across the globe. By putting a MLAT, are we not restricting one side of the free flow, but it's not a symmetric flow? So the data which is stored by somebody else, if anyone requires it, as per the legitimate framework, it should be left to the country, that respective country, to see how they process data, how to do that. There is a judiciary everywhere. There is some rules, regulation is their system, which checks if the account balances are there. Is it fair that you ask for a free flow of information one direction, when it comes to other side, you subject to MLAT? I agree with her, whether you call MLAT or you call anything, there should be a more free flow of information. The information should be available and may not be the real time, in the real time. Certainly, I mean, India is looking very curiously what the arrangement comes up between US and UK. The two factor, I mean, for us, if we look at it, one factor, we are very, may we look at how they handle it. Samir also said the judicial part, he's mentioned the judicial part. The UK law and the Indian law are more or less similar. English law and Indian laws are similar. Both UK and India, the powers are given to executive, to the quasi-judicial powers are given there. They're all subject to judicial review in one or the other court, depending on the jurisdiction of the courts there. Let us see how do they address that issue, because he said the judicial, I mean, how do they address those aspects there. The second factor which he said, which he didn't say, but I mean, what I understand, I stand to be correcting, is the Budapest Convention. Now, does it mean that are you forcing the countries who are not part of a Budapest to become a Budapest things, and then you become the part, I will negotiate bilateral GT with you? That's one part. Are you forcing? Or I will, if I don't become a Budapest Convention member, then you have to sign Budapest and do that. So, I mean, there are issues. I mean, we are waiting for the things to be made public, and I think, I'm sure they will find an answer. But these are the issues which we have. As I said, these are not a simple issue. These are very complex issues. But we need to look at it. In my view, if I have to do, I will discuss one of the cyber norms as a major part. How do we exchange? Because if we don't exchange, if we don't liberalize our exchange of information, it's going to impact our every aspect of digital economy, which we can't afford. Technology is far ahead. We have to move digital toward digital side. We can't come back. So I think these are complex issues. We need to look at it.
And just while I have you, in terms of one of the principles behind the U.S.-UK agreement and the legislation that would implement it and similar possible arrangements going forward is based on the premise that the United States government could establish some minimum human rights and due process requirements that they would need to see in any country with which the U.S. would strike a deal for this more expedited access. Does that make you uncomfortable, or do you think India would happily satisfy those human rights requirements and everything would be fine?
See, India is a declaratory member of the UN Rights Commission there. We have agreed to those things there. We follow human rights very strictly in our country. There is no issue regarding to human rights. But my issue comes up whether the US government will judge the human rights or internet company will judge the human rights. Today, when a request goes, it's the internet companies who are exercising jurisdiction rather than the US government there, any government. Then issue comes up. We are member of the declaration, we are member of everything, we follow there. I don't think there is a single case that has come on India ever for the last 30 years I am saying where there is a case of human rights violation. There is not a single one. We are a democratic country and our media is very strong and everything we see the checks and balance everywhere is there. Yes, I mean we have no issue when you talk about the human rights part, but that should be very clear. It should be done by the government, not by the company who is storing the data.
Great, thank you. So turning to Sri Lanka, do you want to tell us a little bit about how you view the MLAT reform problems there?
Thank you, Andrew. I'm also happy that after several large countries represented on the floor, you turn to a relatively small country which is down under, below India. I come from Sri Lanka, maybe half the size of many of the Indian states, or less than half the size. Well, I think the problem we face in terms of access to electronic evidence on the cloud and the challenges associated with MLAT is similar or more complex than what other speakers mentioned. Perhaps when a law enforcement agency or a judicial authority makes a request, some larger countries may even wonder where Sri Lanka is. I mean, they may not have even heard of it. So you have complex scenarios like that, and it is harder for least developed economies to negotiate direct agreements than the manner in which US-UK kind of agreements were formulated. It's very difficult for us to do that. We neither have the economic capability, neither do we have the volume. So I'm happy that in this forum I commend the organizers of the event, ORF, for bringing in the true sense of digital inclusion small countries like us into the discussion fold so that we have an equal voice in this process. At the beginning you were asking about three options, three possibilities, and it's interesting, historically given the challenges we faced through the years, from the complex terrorism issue to money laundering issues to many other challenges, the delay in obtaining electronic evidence was such that by the time it reached the requested country, the data is already gone. And the volatility of electronic evidence is a huge challenge that we all have to confront with. And this whole issue of cybercrime cannot be disconnected with the whole aspect of electronic evidence, for the simple reason that we have electronic evidence issues coming up in practically every single criminal offense that is committed, whether we talk of drugs, child exploitation, child abuse images to many other things, right? So electronic evidence is the crucial factor that underlines all these aspects. Now, that said, we also have a further complex problem that we are confronted with many of criminal users of the internet using cloud platforms very effectively for their wrongful conduct. So with cloud issues coming up, there are a whole host of jurisdictional challenges, and I like to identify some of them which I have noted down here. Are we, for example, in relation to enforcing or gathering electronic evidence from the cloud, what is the jurisdictional norm that we have to rely on? Is it based on the location of data, the nationality or location of the data owner, the location of the data controller, or is it the headquarters of the cloud service provider? And I know quite a lot of the service providers are represented here. Then, if not, is it the location of the subsidiary or the sales company of the cloud service provider that we go after? Or is it the territory where the service is offered or directed at? And our law enforcement, as much as yours or any others, have faced these challenges daily, if not hourly. And what I have to say is that we found an answer to sum up or conclude the first round of discussion on the subject. We found an answer by helping Sri Lanka join the Budapest Convention, and as of 1st of September 2015, we are a full state party to the Budapest Convention. And with it, we managed to see how effectively this can be addressed, because you asked at that point, at the initial stages, whether we should amend the Budapest Convention. I am of the opinion that the Budapest Convention has evolved effectively. Why? Because it has something called the Cybercrime Convention Committee, under which it has got guidance notes being formulated by the Bureau as well as the Cloud Evidence Group. And I think I saw somewhere in the audience Alexander Sager, Executive Secretary of the Council of Europe, Cybercrime Committee. Maybe he might be able to add value to the discussion. And in 2014, the Cybercrime Convention Committee, which administers the Budapest Convention, came up with some concrete recommendations how mutual legal assistance provisions can be enhanced and made more effective using the Budapest Convention as a tool. And somewhere around the discussion, I would like to emphasize on some of those recommendations. And the latest, the new kid on the block is that the Cloud Evidence Group, just a few weeks ago, finalized a series of recommendations that may perhaps lead to the negotiation of a protocol or a guidance note. And it is important that we again have other countries on board, and I hope India will join the discussion at least by that stage. With that note, I will.
Great, thank you. Devin?
Okay. It's on? Yes, it is. A little difficult to say much more after this many smart people have said a lot on this space, but I think the key thing there would be to remember that 1 and 2 are the most promising going forward. The ability to really work on it, and just to recap at this point, the notion of speeding up the process, some sort of alternative system like the US-UK model that's being proposed. I also think that some of the things that have been said crystallize a few points that have been in the debate, one of which is the sensitivity that both sides need to have an understanding about where they agree. And my concern with the global convention movement is that sometimes there might be one country, such as India, that objects to things that have nothing to do with MLA that are rolled into a convention. And I think it would be sad if that was a roadblock to the need for MLA that everyone's recognized. At the same time, I think what Mr. Jain pointed out is very important, which is, as I understand the U.S. position, it is to say, here are the key substantive things that we are looking for. And so we would like to know what countries are doing that are similar, but not necessarily looking exactly like what the U.S. does. And that, in that sense, should be, I would hope, vice versa. And that also then helps carve out other touchy issues. So for instance, the fact that the U.S., what my colleague and my group, Professor Peter Swire, has talked about, things in the U.S. that we call plus factors, the structural issues, such as an independent judiciary, as well as substantive things such as judicial oversight that travels with that judiciary. But at the same time, in terms of the more structural issues, there is a strong point about not requiring data retention. There are strong defense of encryption in the U.S., but that is not yet a stumbling block for at least the UK option and hopefully others. So it might be appropriate in the near term to build out the ability to have maybe not a full-blown 100% solution of an MLA, but I think the notion of the single point of contact on both sides would accelerate the process enough to then learn where are the sticking points and where further negotiation happen. And that also is important to my mind because, as everyone knows, the digital space moves at an absurdly fast speed. So having a mutual understanding not entrenched in a convention might be more useful to be nimble about, okay, we now agree this is a problem, or we just want to renew because everything is working just fine. And then, if you don't mind, I had a question for Dr. Rai, that if I wanted to understand, and correct me if I'm mistaken, I thought I heard you say that you believe that sometimes there's a lack of general free flow of information, and sometimes it seems as though an MLA process will be imposed. And I was a little lost. Do you perhaps have an example of where you think there's a general lack of free flow of information and its relationship to the MLA?
Before you answer, let me just say that Dr. Rai, our distinguished guest, has to slip out. So maybe you'll answer this question and then
answer this
make
point.
your exit.
See, I did not say that sometime the information is free flow information, sometime I'm not saying that. What I said is that on one, there is no symmetric flow of information. See, on one, you have a one side flow of free flow information asking for, but the other side you are putting to a law. My larger question is that, see, from technology, you are also from one of the great university. We had a 1G, 2G, 3G, 4G, 5G solutions. How did we migrate from 2G to 3G? This is the era of 4G and 5G. Should we go from 2G, like in the MLAT process, tinker the 2G and try to address that MLAT in this cyber virtual scenario, which is getting more and more complex? Or should we look at some next generation? We all talk about next generation technology, next generation things there. Look at it. I mean, is there a case? My friend from Sri Lanka, I said India will look at Budapest. Is there a case for looking for a fresh jurisprudence in the cyber? That's what we need to see. But I'm convinced you tinker with 2G and try to answer 4G or 5G, it will be very difficult. Try it, it will not work. Thank you.
On that note, thank you, Dr. Rai.
Thank you very much. I take this liberty, all of you, to leave. I think I have to meet the ambassador from Netherlands, and I have to rush to the office. Thank you.
Thank you so much. We've scared them off. So, I think a question for Samir. Building off of what Dr. Rai just said, and one of the core challenges of the MLAT problem is essentially its asymmetry. The fact that the United States government receives thousands of requests for mutual legal assistance a year with regard to digital evidence, but doesn't make thousands of requests a year. Do you see that as a real hindrance to reform? And could you talk a little bit about the ways in which that might prove difficult?
I mean, I'm not sure I would characterize it as a hindrance to reform. I think it does mean that, I think we recognize that, it does mean a couple of things. One, it means that the scale problem that we're talking about hits us really hard because we're the recipients of those thousands of requests. And I think, in part it makes it incumbent upon us, and we're trying to take steps in this direction to improve the efficiency with which we handle these requests. So we're putting more resources toward our ability to handle sort of more traditional MLAT requests. And I think it's also why we have really given thought to, okay, what are ways to supplement the MLAT process to to take some category of requests, some subset of requests, and here, in the US-UK context, we're talking particularly about requests that don't involve US persons, and try to create a different system that, frankly, doesn't even need to have the government in the middle, where other governments can go directly to providers. And the hope is that in turn will redound to make the MLAT process more efficient as well, because if that substantial category of requests will eventually, as this framework develops and is extended to other countries, sort of mean that a good chunk of the requests will go straight to providers and not involve the US government. That in turn means we can devote the existing resources even more so to other MLAT requests. And so the idea is that there'll be a self-reinforcing cycle there as well.
Anna or John, do you want to share with us what your thoughts are about this? Do you feel like the United States government would be more cooperative if it was needing from you as much information as you need from it, and vice versa?
I think actually we have very, very good cooperation with the Ministry of Justice from the US when it comes to MLA processes. So we're trying very hard to have personal contacts with them, personal meetings, and explain what are our problems and so on. But we understand, of course, that we're a small country and you have a lot of requests. And yeah, maybe that's always the problem, that you are on the demanding side and not on the giving side, so to speak. But I think, generally speaking, we have a very, very good cooperation. So it's more about speeding up processes, finding new techniques and so on how we can transfer requests and make it easier to handle them electronically, for instance. We have, within the European Union, we're currently in the process of setting up web-based solutions on sending and transmitting and receiving MLA requests, which I think can at least speed up some parts of the process, but in the end there will be someone that has to sit down and think, what is this request about, and follow the rules and adhere to the legal principles and fundamental rights. And we shouldn't forget how important that is, so we can't cut any corners.
I agree with Anna. We also have had good cooperation with United States authorities. However, I just want to emphasize again, what if the electronic evidence on the cloud has moved through multiple jurisdictions, and the challenge is locating and identifying the jurisdiction. So sometimes, yes, true enough, if we have a arrangement with the United States, yes, we would normally have very good cooperation from the United States Department of Justice. But then there may be instances where the cloud service providers' policies and their terms and conditions would mean that data may be located in Ireland or some other location. So what do we do? So that's where small countries like us felt that the Budapest Convention approach was the best way forward, because the convention has evolved itself, and the technology neutral enabling environment it creates has allowed that convention to meet real-time needs, and through a system of guidance notes and so many other documentation formulated by the TCY, it has been able to provide a set of standards and procedures which are applicable commonly, which may become applicable commonly, so that each of us will know what other countries will really require when we make an MLA request.
Great. So we're running short on time, but I want to invite anyone from the audience to pose a question to the panel about MLAT reform. We have a few mics scattered around. I think there's one here.
Should I go first?
We'll start with KS and
Okay,
then
all right.
this gentleman, and then we'll wrap.
MLAT is the result of the constitutional rule of thumb that officials that are politically accountable to the subjects of surveillance have the authority to approve surveillance on that person. So if surveillance takes place on a country, one country's person, but in another country's territory, that is intrusion into privacy, both of the data subject, but also the privacy or confidentiality of the server operator who has held the data for him. So MLAT solves the problem. MLAT responds to the problem by.
Can I ask?
Yes, I'll make it short. By making the surveillance request go through both judges or both jurisdictions, and but that's a bigger question. How we're going to get around the 100 years of a constitutional tradition of making politically accountable the officials who should be concerned about the privacy of the subjects, making them, empowering them to make the decisions. But my question for the panel, probably to Mr. Samir Jain, is this. So the surveillance request only on non-citizens will be allowed to be filled by, for instance, U.S. Intermediaries. Now, that will open a whole new problem for intermediaries, because now they'll have to discriminate amongst the users by the citizenship, by the user's citizenship. And
sorry, we're really short on time. So just the question is,
and that goes against the nature of the internet, where anonymous communications have taken place across the borders. So I was wondering, whether you have any.
Great. Before you answer, can we collect the other question, and then we'll finish.
Alexander Seeger from Council of Europe Cybercrime Convention Committee, which is a committee of 100 to 140 people every time from 60 plus countries, and they're all practitioners. They're cybercrime investigators, prosecutors. If they are from Ministry of Justice, they're responsible for cybercrime policies or for mutual legal assistance. So it's practitioners, which means the analysis they are doing and the recommendations they are bringing forward, they are not of general academic value, they are of practical importance. The good thing is, if the UK-US agreement comes into being, you don't have to change the Budapest Convention, because it's already in the Budapest Convention, Article 18, it's already there, and it's practiced by most countries around the world in other sectors than service providers, banks, other companies. If a branch of a company is in your country, you can order the production of data, and that bank or branch of a bank has to repatriate the data if ordered based on a court order or whatever. So it's already there. What is the issue here is domestic legislation. The Cybercrime Convention Committee has analyzed the question of mutual legal assistance. Yes, we have to make mutual legal assistance more efficient. We cannot do away for it. It's there also to protect the rights of individuals. But we have to make it more efficient. Now, two scenarios, because we have Sweden here, we have Facebook here, we have Microsoft here.
Can you make it one scenario with a question?
No, because it's important with all these people here, and we can discuss the solution afterwards on the lawn or over whatever. The first one is, Facebook has a server park in Luleå in northern Sweden. So and I discussed with your prosecutors, your police officers. They may see the server park from their office. If they want to investigate, of course they could go and seize 125,000 servers. Will not help them much. So they have to send for subscriber information a request to Facebook in Ireland, for content data to United States. So the fact that the location of the servers is in Sweden has no relevance whatsoever on the cooperation. Now, another scenario. This morning, assume it's hypothetical. This morning I opened the Outlook account. Bill.Gates was already taken, but 2016 was not taken. So Bill.Gates 2016, and I could choose the jurisdiction. It pointed me at India, but I thought, no, that's too obvious. I took the next one, Isle of Man. So let's assume I commit a crime, and the Indian authorities want to investigate the crime linked to this Facebook account, Bill.Gates 2016 at Outlook.com. To whom do they go? And how would they know that the jurisdiction is Isle of Man? Thank you.
Okay, 2 non-questions. Would you like to answer either of them?
I mean, as to the first question, I think it's, look, I mean, it's a fair, I think in some ways what you said at the end relates to what you said at the beginning, which is that the interests of the US government are different if we're talking about the data of a US person versus a foreign person. And that's why the legislation really draws that distinction. It says, look, if it's data about a US person, then the standards that apply in the United States, the probable cause standard and the like, still have to be met, and so we have to use the traditional mutual legal assistance process. Whereas if we're talking about a non-US person, then we are willing to create this more flexible and alternative system where you can go to the provider, and it really is frankly a matter of the level of interest that the US government has in those different scenarios. And I'll leave it at that, given our time constraint.
Great, yeah, so we unfortunately have to wrap. We're running a little bit behind time, so with an enormous amount of material left unsaid. Thank you very much for your attention. All of us will be milling around waiting for your questions over coffee. The next panel will start as soon as Arun tells us that it will. The next panel on supply chain integrity. So thank you very much.